Hello and welcome to Discover Series 3, the third in the series of online education sessions brought to you by Salts Healthcare. Over recent months, I think we can all agree that at times we have found things challenging, both in our personal lives and professionally. One thing that has had a significant impact on our lives is the ever-evolving technology and how it is entering our everyday lives in so many different forms. 20 years ago, a supermarket self-checkout would have been a bizarre concept. Nowadays, it is the norm, as is paying by PayPal or Apple Pay, as well as us working with paperless systems in our hospitals and workplaces. All these advances are a result of the increasing 21st century technology we have at our disposal. All are reportedly designed and developed to make our lives easier, and in so many cases, they do. As a result of the recent pandemic, we have all needed to make specific changes to the way we practice. Some of these changes have proven to be cost-effective, equally as efficient, and in many cases continue to provide optimum care for our patients. So undoubtedly, they will continue to remain as an integral part of our care. However, it is important to be mindful of the impact that the digital age is having on us. With that in mind, our first speaker, Kate Pleasant, will be exploring the legal obligations with regards to accessing and storing patient data and what our responsibilities are in respect to GDPR. Kate trained as a solicitor and now works as an associate within the commercial and data protection team at Knights PLC. She advises on all aspects of data protection compliance, including policy and contractual documents and data breach handling. Kate has also been involved in the delivery of a large-scale data protection compliance audits for a number of clients, and on a day-to-day basis coordinates the delivery of subject access request responses on a fully outsourced or advisory basis as required.
Hi everyone, my name's Kate and I'm an associate solicitor at Knights PLC specialising in data protection. This presentation is intended to give a high-level overview of current data protection law in the UK and in particular how this is relevant to your role as a nurse. The purpose of this training session is to provide you with some practical tips and guidance on how to handle personal data lawfully and hopefully keep you on the right side of compliance. It's intended to upskill you so that you have a working understanding of current rules and regulations and to help you spot and deal with data protection issues in practice. Here is an agenda of what we will cover in today's session. We'll start with a brief overview of the current legislation applicable in the UK and the possible enforcement action and penalties that can be imposed for non-compliance. Next, we will learn what the term personal data actually means and what types of information these rules are designed to protect. We'll then move on to cover the 7 principles of the GDPR and what they mean in the context of your role as a nurse. I will then give a brief overview of the rights individuals have in relation to their own personal data, followed by an explanation of what a personal data breach is and what that means for you. Finally, the session will close with a reminder of your data protection obligations as a nurse and our top tips on how to meet these obligations in practice. The key piece of legislation in this area is the General Data Protection Regulation, known as the GDPR. The Data Protection Act 2018 sets out the framework for data protection law in the UK. It updates and replaces the Data Protection Act 1998 and, like the GDPR, came into effect on the 25th of May 2018. It sits alongside the GDPR and tailors how the GDPR applies in the UK. In practice, we think of the GDPR and the new Data Protection Act collectively as a framework of legislation, and usually we don't need to distinguish between the two, so you may hear the terms used interchangeably. Data protection law in the UK is regulated by the Information Commissioner's Office, known as the ICO. The ICO are responsible for overseeing data protection law in the UK, investigating any issues and enforcing compliance by issuing fines and enforcement notices where necessary. In effect, the ICO are the data protection police. If something goes wrong, data protection-wise, the affected individual might look to complain to the ICO. The ICO have produced and are continuing to develop a suite of guidance notes and codes to help us navigate data protection law. If you're interested in developing your data protection knowledge further, I would recommend taking a look at the ICO website. The guidance notes are really practical and can answer a lot of frequently asked questions. They also have sections specifically targeted at health data, which may be particularly helpful to you. I move on now to mention penalties and enforcement. Under the previous law, the ICO had the power to issue fines of up to £500,000. Under the GDPR, these powers have been extended substantially. The ICO can now issue fines of up to 17.5 million or 4% of annual worldwide turnover, whichever is higher. This is one of the reasons why it's so important that we all take data protection compliance seriously, because if things go wrong, the consequences can be really severe. In most cases, the ICO will fine the organisation for non-compliance. However, it is possible in certain circumstances for the specific individual responsible to be fined or prosecuted. I will now mention some examples of recent ICO enforcement action to put into context the gravity with which data protection issues are being handled. Ticketmaster was fined £1.25 million for failing to protect customers' payment details. Marriott International was fined £18.4 million for failing to keep millions of customers' personal data secure. An estimated 339 million guest records worldwide were affected following a cyber attack in 2014. Doorstep Dispensary, a London-based pharmacy, was fined £275,000 for failing to ensure the security of sensitive types of personal data, including health information. Approximately 500,000 documents were left in unlocked containers at the back of its premises in Edgware. The documents included names, addresses, dates of birth, NHS numbers, medical information, and prescriptions belonging to an unknown number of people. Kim Doyle, a motor industry employee, was prosecuted for passing the personal information of service users to an accident claims management firm without authorization. She was sentenced to 8 months imprisonment, suspended for 2 years. Kim unlawfully compiled lists of road traffic accident data despite having no permission from her employers. She then transferred this data to William Shaw, the director of an accident claims management firm. William Shaw was also sentenced to 8 months imprisonment, suspended for 2 years, and both were ordered to carry out 100 hours unpaid work and contribute £1,000 in costs. Doyle must also pay a benefit figure of £25,000 and Shaw must pay a benefit figure of £15,000. Both will face 3 months imprisonment if the benefit figures are not paid within 3 months. I've picked out a variety of examples to show how the ICO can take enforcement action against organisations of all sizes and individuals personally, and the consequences that this can have. Some of these cases have been handled under the old data protection law due to when the issue actually occurred, and so had they been dealt with under the new law, the fines might have been even greater. I'm not telling you this to scare you, but rather to emphasise the importance of data protection law and the potential consequences if things go wrong. It's also worth mentioning that individuals whose personal data has been treated unlawfully can make a direct claim for compensation through the courts. In either case, there's also a risk of reputational damage in addition to the potential financial consequences where things go wrong. The ICO published details of the enforcement action they've taken on their website, and claims for compensation in the courts may be reported in the press. The whole purpose of the GDPR and Data Protection Act is to protect personal data, so naturally we need to understand what personal data actually means. In essence, personal data is any information relating to an identified or identifiable person. This means that if information identifies a person, either directly or indirectly, it will be personal data, including, for example, online identifiers such as usernames or IP addresses in some circumstances. On the slide, you will see that I've listed some examples of information that would constitute personal data. This is not an exhaustive list, but gives you an idea of the types of information that we are talking about. Interestingly, an opinion about someone can constitute personal data. This could include an opinion on someone's medical condition or lifestyle. So pretty much anything and everything about a living person has the potential to be caught by the GDPR. Special category data is more sensitive personal data that benefits from additional protection. This includes health information. For the purposes of your role, this means that it's even more important that this information is kept safe and secure and handled in accordance with data protection legislation. Criminal convictions data also benefits from additional protections, but I won't go into that for the purposes of today's course. I now move on to discuss the 7 principles of the GDPR. The principles lie at the heart of the current data protection regime and are fundamental to the protection of personal data. In respect of each principle, I'll set out the key points. These are the points that you should bear in mind whenever you are doing anything that involves personal data, whether this relates to patients, their families, or anyone else whose personal data you might handle as part of your role. The first principle is lawfulness, fairness, and transparency. You must identify valid grounds under the GDPR for collecting and using personal data. For the most part, this will be dealt with within NHS privacy policies and notices made available to patients in connection with the care they are receiving. A privacy policy will generally set out what types of personal data are collected, how this information is used, and the lawful basis for the collection and processing of this information. There are 6 lawful bases available under the GDPR. As a nurse, you should familiarise yourself with the applicable privacy policies and notices issued to your patients and ensure that you are handling personal data in accordance with this documentation. You must use personal data in a way that is fair. This means that you must not process the data in a way that is unduly detrimental, unexpected, or misleading to the individuals concerned. The main point for you to take away from this is that if you think an individual wouldn't expect you to do something with their data, you probably shouldn't be doing it. A good question to ask yourself is, if I was in their shoes, how would I feel about this? You must be clear, open, and honest with people from the start about how you will use their personal data. Again, the necessary privacy information is generally communicated to individuals by way of privacy policies and notices. It's therefore fundamentally important that you only process personal data as set out in the relevant privacy policies and notices. In particular, you must not begin any new types of processing of personal data unless this has been authorised by the data protection officer or other appropriate individual. Next up is purpose limitation. In essence, when you first start collecting personal data from an individual, you will, or certainly should, have a purpose for requiring that information. The purpose limitation principle prevents you from then using that personal data for another purpose. You need to be clear with people from the start what you will use their personal data for. Under the data minimization principle, you must ensure that the personal data you are processing is 1, adequate, sufficient to properly fulfill your stated purpose, 2, relevant, has a rational link to that purpose, and 3, limited to what is necessary. You do not hold more than you need for that purpose. In other words, don't ask people for data that you don't need. If you are required to take a photograph of a patient, ensure that you only capture the relevant area and keep family members or visitors out of the shot. Remember, the more data you hold, the more data you have to protect. Moving on to accuracy, you should take all reasonable steps to ensure that the personal data you hold is not incorrect or misleading. If you discover that personal data is incorrect or misleading, you must take reasonable steps to correct or erase it as soon as possible. So, if a patient or family member lets you know that their personal details have changed, you should take steps to update this on your systems without undue delay, or you could be breaching the accuracy principle. The storage limitation principle means that you must not keep personal data for longer than you need it for. You need to think about and be able to justify how long you keep personal data for. This will depend on your purposes for holding the data, and there may also be applicable regulations or policies requiring you to retain certain types of information for a specific length of time. The integrity and confidentiality principle means that you must ensure that you have appropriate security measures in place to protect the personal data that you hold. This is known as the security principle. This is an area in which the ICO have been keen in taking enforcement action. Some of the enforcement action examples we looked at earlier related to breaches of the security principle, where organisations have failed to adequately protect personal data. This can be anything from not password protecting your phone or iPad to leaving a file on the train or leaving your office or filing cabinet unlocked. In relation to electronic processing specifically, you should ensure that you use work-issued devices with appropriate security measures and do not use personal devices for work purposes unless this has been authorised expressly. If you are taking video or telephone calls from patients, this should be done in a private space where you can maintain confidentiality. Avoid taking calls in public places where sensitive information may be overheard. The accountability principle requires you to take responsibility for what you do with personal data and how you comply with the other principles. You must have appropriate measures and records in place to be able to demonstrate your compliance. Some of these principles will largely be more applicable to your employer at a higher level, but hopefully they give you an idea of the foundations of the GDPR and how it seeks to protect personal data. As a nurse, you should bear in mind the principles whenever you are dealing with personal data, particularly with respect to security, data minimization, accuracy, and storage limitation.
Incidentally, if a patient sends you a message or picture electronically, you should take steps to ensure that this is received and stored securely. Again, avoid the use of personal devices unless the use of these for work purposes has been authorised by your employer. Encourage patients to contact you via your work devices, which you and your employer can ensure are password protected and appropriately secured, for example, by way of encryption. Remember that the use of third-party platforms or social media may not always be secure or reliable. If a patient does send you a message or image by way of a third-party platform, you may need to store this in an alternative format, for example, by uploading it onto the patient's electronic file and erasing it from such platform to ensure that it is stored securely and reliably. Speak to your employer if you are unsure of the authorised platforms in which you can safely receive and store information. Remember that even if you do not have a patient's number saved in your phone, they may still be identifiable by way of their telephone number or other electronic identifier.
Whilst the principles lie at the heart of the current data protection regime, the GDPR extends further than this and gives individuals certain rights in respect of their data. These are as follows. The right to be informed. This means that individuals have the right to know how their personal data is processed and is predominantly dealt with by way of the privacy policy. The right of access. Individuals have the right of access to their own personal data, subject to certain exemptions. The right to rectification. If the information you hold about someone is wrong, they have the right to ask you to correct it. The right to erasure. In some circumstances, individuals have the right to ask you to erase the personal data that you hold about them. The right to restrict processing. In certain circumstances, individuals can ask you not to use the personal data you hold about them. The right to data portability. Individuals can obtain their data in a portable format that they can use for other purposes. The right to object. Individuals can object to some types of processing. For example, they can object to their data being used for marketing purposes. Rights in related to automated decision-making and profiling. This applies where you are using someone's personal data to profile them or make automated decisions about them. This is a bit of a whistle-stop tour for the purposes of this presentation, but it is important that you are aware that these rights exist so that you can spot and escalate any request to exercise these rights. The most commonly exercised right is the right of access. If you receive a request from a patient or any other individual to access their personal data, you must escalate this request to the appropriate member of staff within your team promptly. It's important to note that an individual does not have to use the word access or refer to data protection legislation in order for a request to be valid. Any request for personal information may constitute a subject access request for the purposes of the legislation. Further, a request can be made in any format, in writing, verbally, or even by social media. It's important that you escalate the request promptly, as there are statutory time limits for responding. You should not respond to the request yourself unless you have received appropriate training and this is part of your role. However, your data protection colleagues may need you to assist with the searches for the personal information requested, and you should provide such assistance promptly and diligently. It's also worth bearing in mind whenever you make a written record about someone that they may one day access that information. With this in mind, it's important to always use professional and courteous language. I'm now going to talk about personal data breaches. This is basically the term we use when things go wrong, when personal data is lost, destroyed, corrupted, or disclosed without proper authorization. A few examples. You accidentally leave some files containing personal data on the bus or the train. You send an email message or a text message or other electronic message containing patient personal data to the wrong patient. You accidentally delete a patient's record on an electronic system. Your email account is hacked and the hackers gain access to patient personal data. There are certain rules with respect to data breaches which, depending on the severity of the breach and the likely risk to the individuals concerned, may mean an obligation to report the breach to the ICO and, in more serious cases, may also mean reporting the breach to the affected individuals. Breaches must be reported without undue delay, and there is a 72-hour time limit to do this, which begins when the breach is discovered, where the breach is reportable. For this reason, it's fundamentally important that you are alert to data breaches and report them to the appropriate team as soon as you discover the breach. Accidents happen, and whilst you should be taking steps to prevent data breaches as much as possible by keeping personal data safe and secure, it's not possible to plan for every eventuality. Due to human error or targeted hacking incidents, sometimes personal data breaches happen and there's nothing we can do to stop them. For this reason, even if it happened accidentally, data breaches must be escalated so that they can be dealt with appropriately. Don't try to cover them up, because this can just make things worse and may create a difficult situation if the breach is later discovered once the time limit has expired. It may also be necessary to take steps to contain the breach, which is another reason why you should escalate it as soon as possible. This might involve putting in place further security measures, or, in the case of an electronic device being lost, for example, disabling the device remotely if this is possible. If you notice anything suspicious, such as a dodgy email that looks fraudulent, perhaps a hacker impersonating a colleague, or you realise that you've accidentally sent an email to the wrong person, or lost a hard copy file, or anything which you think has the potential to constitute a personal data breach, report it to the appropriate colleague or team as soon as you can. You are the people on the ground dealing with personal data on a day-to-day basis, so it is fundamentally important that you are aware of your data protection obligations and prepared to spot and escalate issues appropriately. Remember to use appropriate language whenever writing an email or making a written record or even a recorded phone call or voice note. The person you are writing about may one day see what you have written about them. Keep in mind the 7 data protection principles as you go about your role. Data protection legislation is not there to get in the way of your day job, but is there to ensure that personal data remains protected and secure. If something doesn't feel right, it probably isn't. Put yourself in the patient's shoes and consider how you would feel if you were them. In practical terms, make sure you keep records safe and secure. Don't ask for data that you don't need, and make sure you are being fair and transparent with people as to how their personal data will be processed. Remember to make sure that your devices are password protected and that you are not using personal devices for work purposes unless authorised to do so. When taking photographs, only capture what is necessary. Thank you for watching this presentation. I hope it is helpful. If you would like further advice or guidance on data protection, the ICO website contains lots of helpful resources and advice. Thank you again, and goodbye.
Thank you, Kate, for highlighting some of the specific challenges that sometimes arise for us as stoma care nurses, working with the multitude of technologies that we have been increasingly working with over recent times. Thank you for watching this first episode. We do hope you have enjoyed it, and it has been able to offer you insight into what we should all be doing to keep data safe and secure. This episode can be viewed on demand from Salts Healthcare website, so it can be stopped and replayed at your convenience, giving you time to write notes or reflect on certain aspects of the session. If anyone has any follow-up questions, then please do email us at discover@salts.co.uk. Please do click on the link at the end of the episode or from the main Discover series page on the Salts Healthcare website to access the evaluation form. On completion of this evaluation form, you will be redirected to a page enabling you to print out your certificate of attendance. The next session in the Discover series will be launched on Thursday, the 18th of November. Within this session, Mark Cooley, a senior associate at Irwin Mitchell Law Firm, explores the issue of obtaining consent in a virtual world and how robust is this in a court of law. Looking forward to seeing you all soon.